contraception is a matter of life and death for women, to really push the narrative that this isn't a political tool, political football you can manipulate to gain votes. If women don't have access to contraception, they are going to die. That their life is going to be radically different. And also stress that this impacts poor women the most. They're the ones who are going to bear the burden for not being able to access reproductive services. What's frustrating though in this decision is that this hints in the inquiry that it's the role of the Catholic Church in the Philippines is sort of underpinning this ban, and that doesn't really get fleshed out openly enough. That what role culture plays in limiting women's rights, particularly women's sexual and reproductive rights, probably could have come to the fore a bit stronger. So in sum though, that the committee's reporting, this inquiry procedure is fleshing out women's human rights, providing more detail, more nuance to the CEDAW obligations. So achieving structural change is obviously a really difficult question, and it's really hard to pin down what we mean by structural change and how we measure it, which we saw talking yesterday. So for my paper, I looked, rather than trying to figure out de facto on the ground structural change, I did it more simply and looked at, the committee gives a bunch of recommendations, have states tried to implement them? So is the state listening to the CEDAW committee? And it's a bit of a mixed bag. It's very evident in looking at these reports and looking at what happens afterwards that political will is a key ingredient, which is obviously pretty well known. Which maybe also points to the fact that the committee has to, one of the things that's very obvious as well is that the committee's recommendations can be a bit general. And that might be a function of them being an international body. And what might make this more effective is if a domestic inquiry procedure is held, they have a better understanding of the local context and can perhaps make more nuanced or pinpoint more specific concrete recommendations that could perhaps be more effective. But on a whole, the states generally listen to the committee. So in Mexico, they passed legislation on violence, they put a national registry for missing women, developed early alert systems. In Canada, they put this national inquiry into murdered missing women, Indigenous women. It hasn't gone off the ground very well. It's been mired in a lot of controversy, and argue that was due to change in government than maybe the effect of the CEDAW committee. And then the Philippines did repeal the ban and revoke the acts and put in a healthcare act. But again, unfortunately, I was just Googling the other day, another city in the Philippines tried to put in a contraception ban. And the federal government in the Philippines did try to come in and stop it, but obviously the impetus for these contraception bans is still well and alive, and the inquiry procedure maybe hasn't quite gotten to the social norm change we want to see. So is it achieving structural change? It's a mixed bag, right? Because we can see things, there's lots of evidence, again, Googling about Mexico, there's still rampant violence, there's still an issue of murder and missing women in Canada, there's still bans on contraception in the Philippines. So de jure change doesn't mean de facto, but we can see that states are at least listening to the CEDAW committee, which for an international human rights lawyer is always something optimistic. And then the last sort of maybe benefit of the inquiry procedure, I think is maybe one of its strongest, is that it can really rethink about how women access justice. The barriers to women accessing justice are relatively well known. There's biased decision making. I was reading the paper the other day, a judge in Quebec made a comment that a woman was coming with a claim of sexual harassment, and the judge said she must have been flattered by the attention. Mm-hmm. So those kind of biased decision making from judges is still sadly alive and well. There's stigmas of coming forward to claim your rights. You know, we've been talking about Me Too and Harvey Weinstein. These women have to be brave. They know they're going to there's a risk they're going to face pushback. There's fears of retaliation. Women have a lack of knowledge of their rights or identifying what sexual harassment, sexual assault is. Legal protections might not be in place, so you might not have a right in the country. Evidentiary rules are another huge issue. I was reading about the Bill Cosby trials and his sexual assault. A lot of his sexual assaults are now barred by statutory time limits in the US. So and the rules of cross-examination can all work against women being able to achieve justice. And then there's the costs, the time, the expense, the publicity of it. You're taking on a burden by trying to claim your rights. And my claim is that, well, the inquiry procedure can really shift that burden from one individual to a collective of people. So it's the people doing this tend to be women, and they're experts in gender equality, so the bias in decision making shouldn't be there. The committee is not limited by rules of evidence, because they're not trying to pinpoint blame on a specific person to met out punishment. They're trying to identify structural problems and figure out structural solutions. So rules about cross-examination, how evidence goes into court are not really an issue. The committee can see the entire picture, not just the one individual claim. It can interview all stakeholders. It can look at things in large context. So in Canada and the murdered Indigenous women issues, it looked at Canada's racial colonial policies back from 1763, something you would never do in a traditional court-like setting. And no one person bears the cost. No one has to come forward and say, I was the one who's been sexually harassed. I'm the one who can't access contraception. It's the committee looking at this in a much global, wider structural lens. So in conclusion, I would argue the inquiry procedure is probably a best practice model for achieving gender justice. It could be something we should think about taking forward in domestic spheres, particularly on the idea that if domestic spheres could have more precision because they understand the local context, and we could think about this as a really legitimate way for lawmaking to start to happen, in that the committee is interviewing so many different types of people, all different types of stakeholders, so the law that gets generated out of that should have a serious amount of legitimacy in that it's been an inclusive process. So on that end, I will conclude just by saying that the CEDAW inquiry procedure has been overlooked, but it's unwarranted. It can offer a lot in how we think about holding government to account for women's human rights. Thank you.
For questions to you, and maybe perhaps to others. Okay, who would like to come there? Right.
Thank you very much. I was wondering if you could say something about the use of the optional protocol, because one of the requirements is that you have to exhaust domestic procedures before you can submit a claim and complaint. And that, in any case, even domestic procedures take so long to be completed that seems to be a retrograde step. The other thing is that I think when you're talking about the inquiry procedures and the effectiveness of CEDAW, what I noticed is that in submitting, I'm referring to the Bangladesh government's reports, I mean, each time they make recommendations, so it's still a bit of a soft sell, because all you can do is make recommendations. The government makes, soft noises, yes, we're going to do it. But unless there is also a backup from local, whether it's legal aid groups or women's movement itself, it doesn't move very fast.
Yeah, so those are really good questions. I think the first one about exhaustion of domestic remedies, that only applies to the individual communications. It doesn't apply to the inquiry procedure. So that's also makes this an exciting remedy, in that you don't have to go through all the court processes in your own country to then be able to go onto the international stage, because it's not about one individual, it's about a group of women. So the inquiry procedure isn't bound by that traditional international hurdle, which is really important. You don't have to prove you've tried this in court and it's failed. You can go right to the committee, which is also exciting because a lot of times, which I forgot to mention, just thinking sort of broadly, a lot of the issues that the inquiry procedure could potentially deal with don't map on well traditional accountability structures. So one of the examples in the literature is discriminatory perspectives, portrayals of women in textbooks. Right? Every woman is potentially claiming about that. There's no one who can say, I'm the victim of this. So the committee can take these claims that we can see happening and do something about that in a way that traditional courts just can't. So it's quite exciting in that way. And as to your question about what do we do with these recommendations, I think that is the perennial question when it comes to CEDAW. They can say all these great things, but they're hard to access. You have to know if the website is hard to access, they're hard to find. I think it depends a lot on, for the inquiry procedure, it's usually an NGO who initiates it. So I think in their strategy about the fact that they've decided to go to CEDAW rather than maybe go through a court, part of their strategy has to be, what do we do with the recommendations when we get them? That kind of like strategic litigators have to think quite globally about, we'll get a decision, what do we do with the decision when we get it? I think the NGOs have to, because it's a soft sell, the government it's not bound to follow CEDAW. So NGOs have to have a strategy for how they're going to implement the recommendations or push the government to implement the recommendations. And then the CEDAW committee has to be seen as legitimate. It has to persuade the government that this is a good idea. And how it does that is a complicated song and dance, in that it has to be sort of accurate. It has to be, it can't be deferential to government. It has to do its searching, inquiring job. But so it has to do it in a way that is seen as legitimate, which means it has to talk to people, it has to be accurate, it has to speak to the context, it has to give recommendations that make sense. So it has to be deeply, I think it has to be very accurate. There's a sort of buzz caption word. So I think there's two ways to make sure these recommendations get taken up. It's never going to be easy, but to have a strategy for the NGO who's brought the claim about what you're going to do when you're successful. And second, the committee has to be speaking to the local context, if that answers your question.
Thank you.
Can you just tell a little bit about the committee, how it's appointed, who sits on it?
Yeah, so it's 23 experts from around the world. I think they sit, I forget how many years, I think, like maybe 5 or 7. The state nominates people. So it's a mixture of lawyers, economists, sociologists, just people in the state who've been prominent working on gender equality. And it rotates all around, so it's got a geographic spread as well. Every now and then there's the odd man, usually from Scandinavia, who's on it, but mostly it's just women. And they're women who've been prolific in their country, and they're independent from their country. They're not a puppet of the government. They are meant to be independent experts who have been prominent within their local discourse about gender equality.
This is really interesting. I hadn't quite appreciated this new procedure. But I have a question about resources for the CEDAW committee to do this kind of thing, because my worry with the CEDAW committee, as with the rest of the human rights system, is that there are procedures that could be quite helpful in the struggle for change. They won't bring about change by itself, but they'd be helpful in the struggle for change. But there's no money. I mean, I was invited to go to Geneva the week after next to a workshop held by the independent expert